Hi, I'm Adam Stofsky with Briefly, and I'm here with Jordan Gustafson from Inland Counties Legal Services. We're doing our family law series, video series, to explain family law issues. And today we're going to talk about something kind of interesting, which is the role of mediation in resolving family law disputes, especially kind of custody and visitation. So, Jordan, let's ask you, so what is mediation? What is the role of mediation? How does it work? What is it?
Yeah, so in terms of child custody and visitation, the courts have what's called child custody recommending counseling. And that's what people are usually referring to when they reference mediation in the family law realm, at least as it relates to custody and visitation. And depending on the county, this can be voluntary or mandatory. But in San Bernardino County and Riverside County, it is a mandatory part of the process when you are trying to obtain child custody and visitation orders.
So this means in any situation where there's any kind of dispute over custody and visitation, the court requires this mediation, this CCRC, right?
Yes, that's correct.
What if you don't want to do it? What if you say, like, which I'm sure is true in a lot of these situations, like there's just nothing to talk about here. Do you still need to do it?
Yes, it is absolutely mandatory. In every case where custody is at issue, the court does have to order the mediation. If the party continues to refuse to participate, they can face sanctions from the court, or the court can just make orders eventually without their participation, which means that they would get custody orders without having a right to participate in the process because they refuse to do that mediation.
So you can kind of look at it as it's your chance to tell your side of the story. So you should be there.
Yes, absolutely. It is one of the, if not the most important parts of a custody and visitation case. The judges rely heavily on the reports that are drafted during these mediation appointments. So it is crucial that you attend and prepare appropriately for these mediation appointments.
Are a lot of cases actually just resolved through this mediation?
There's definitely a fair number. A lot of parties maybe aren't too far apart on what it is that they're requesting, and they just need that third party to help them maybe work out the holiday schedule or help them determine what's the most fair way to split the time, or maybe having that third party insight of, hey, this might be easier for the child transition wise. So there are a lot of cases that are able to come to an agreement, but there's also a probable equal, if not more amount that aren't able to resolve things during mediation.
So how does it work? How many sessions is it? Is it in a physical office? Is it on Zoom? How does the CCRC actually happen?
Yes, and as with a lot of things, procedures are still ever changing since COVID-19, but they are trending towards being back in person. There is still the option for Zoom, especially for San Bernardino County. The primary court for the High Desert is in Barstow, and that's a very long drive for a lot of parties. So they're still offering Zoom. But like I said, there is the trend to get back in person and allow the mediator to have those interviews face to face. But generally, it's only going to be 1 hour long session. So there isn't a whole lot of time to, kind of present what it is that you're asking for. But it's a 1 hour session. Generally, both parties will meet with the mediator together in the same room or in the same Zoom call and go over what it is that they're requesting and why they are requesting that.
What if there was some domestic violence or abuse involved and one of the parties just doesn't feel safe being in the physical room with the other one? How is that handled?
Yeah, so there's actually a questionnaire that the court will require the parties to fill out ahead of time. And part of that questionnaire will ask if there's a history of domestic violence and if there is a request for an accommodation for the parties to meet separately. So if there is that history of domestic violence, there's absolutely a route to request to be either in a separate room, or even if it's on Zoom, they can have separate calls so that you're not even having to have that interaction virtually either.
Okay, that's great. So, and what is the scope of what's decided or what's addressed in these sessions? You said it just covers custody and visitation. What is the range of issues that the mediator can cover?
Yes. So the goal is to determine custody, and there's both physical and legal custody. So legal custody is which parent or parents have the right to make decisions regarding healthcare, education, and just general decisions regarding the welfare of the child. And then physical custody is who the children will be spending the majority of their time with. And then the third component is visitation, which is how does that custody schedule play out in the day-to-day? Is it alternate weekends, week on, week off? Really getting down into the specifics of the plan. It can address who's driving to the visits, who's driving home from the visit. It can be very detailed and address a very wide range of issues.
Okay, so obviously, if everyone agrees with the mediator's recommendations, great, you can have an agreement and then get on with your lives. What happens if you don't agree? If one or both of the parents doesn't agree, what is the next step?
Yes. So in our counties, Riverside and San Bernardino, there is a mandatory reporting to the judge. So the mediator will draft a recommendation to the court that will give a brief summary of what was discussed with each party in mediation, kind of what the parties are claiming as their reasons for the schedule requested. And then at the end, they will offer a recommendation as to what they think the custody and visitation should be. And what they're looking to do is make the orders that are in the best interest of the children. So they may include an explanation as to why they feel these orders are in the best interest of the children. And then the judge can use that recommendation to make their orders at the time of the hearing.
So what happens if you disagree with the mediator?
At the time of the hearing, you can the court will definitely give you the opportunity to address your concerns. They will want to know exactly what it is that you disagree with. So it's important for the parent to be prepared with why they disagree and specifically with what part of the order. It would be go a lot more smoothly than if the party were just to walk in and say they disagree with everything. It's important to specifically list out what it is in the report that you disagree with. And then if you still disagree with the orders the court is making, the party can request a evidentiary hearing, which is an extended amount of time for a court hearing, kind of like a trial, where they're allowed to present evidence and try to, provide counterpoints or counter arguments and show the court why the order should be different than what was recommended.
Okay. So have you have a chance to really go and bring forth evidence and make your arguments to kind of override what the mediator is?
Yes, exactly. Bringing in whether it's text messages, third parties who have witnessed the parenting of both parties, or maybe witnessed an incident of aggression or something that would be relevant to making these custodial orders.
Okay. All right. Well, then, any just advice or tips for people going to, because there's no lawyers at these here. It's just the parents, right, and the mediator in the room.
Correct. There are no attorneys allowed. So even if the party does have an attorney, they do not allow us in the rooms. So it is just the parties and the mediator. In terms of preparing, like I said, these appointments are only an hour. So you can, at best, each party is getting about 30 minutes to really present what's important on this case. So I always recommend sitting down ahead of time and pulling out the most important points that you want the mediator to know. And also to kind of refocus on the best interests of the children, especially in divorce. There can be a lot of issues going on, a lot of issues that are causing contention between the parents, but they don't actually relate to custody. And so it's important to make sure you're just always pulling yourself back to the custody and trying to leave those emotions at the door so that you can really work together to find what's best for the children and leave the kind of divorce emotions out as much as possible.
Right. To focus on the child. Yeah. Really interesting. Okay. So then let me just conclude by asking, how can inland counties help with these mediations? I know you can't be in the room. What can you do around custody and visitation generally?
Yeah, sometimes we can help assist with filling out the questionnaire in advance of the mediation or helping file the request for order that kind of triggers the court to file these mediations and get that case moving along. Or if you receive a report that's not in their favor and want advice on how to proceed or maybe prepare for an evidentiary hearing, or occasionally even representing at the hearing to try to challenge those mediation reports.
Great. Jordan, thank you so much.
Thanks, Adam.